Good afternoon. The Senate Judiciary and House Child Welfare Conference Committee will come to order. Thank you for everyone being here and Madam Chair. And we are going to proceed with just a reviser's overview of the bills that we have in conference committee. And we do have the permission of the ranking minority member of the Senate Judiciary Committee to go ahead with just the reviser overview. In his absence, he is in the Senate and House Transportation Conference Committee right now. So, and he'll be joining us shortly, probably when you're done with the overview of what we've got in conference committee. So with the reviser then, with an explanation. Thank you.
Thank you, Madam Chair. Jenna Moyer, Advisor Statutes Office. And the chart that we have passed out tells you the two bills that are in this conference committee. The first is Senate Bill 115 and the Senate substitute for House Bill 2070. I'll be going over the Senate position on both of those bills, and then the House revised will be going over the House positions. So for Senate Bill 115, it amends KSA 592133 and provides the list of individuals who are to be given notice of a hearing in a petition on an independent or step parent adoption, and specifies who is to provide that notice. And notice is not required to be given to a person whose parental rights have been terminated or a person or agency that has waived their right to receive notice.
Thank you, Revisor Moyer. This is Jesse. I staff House Child Welfare and Foster Care. And so the House version for Senate Bill 115 is that the committee changed the effective date to the Kansas Register. Okay, the other bill that is in conference today is Senate sub for House Bill 2070. So this was originally introduced in the House. What it originally did, what it allowed non-drug offenders convicted of a severity level 7 to 10 felony with certain criminal history scores to participate in a certified drug abuse treatment program. And then it was sent over to the Senate.
And, I will note for the committee that the contents of that bill are currently in a Senate substitute for House Bill 2010, which is in a judiciary conference right now. What the Senate did with the bill is that it stripped the contents and inserted the contents of the substitute for Senate Bill 232, which was the bill that would establish the Office of the Child Advocate in sections 1 through 6, as well as the powers, duties, and confidentiality provisions for that office, as well as a prohibition on retaliation. Section 7 incorporated the House amendments to that, to the House Child Advocate Bill involving federal jurisdiction over sync proceedings that involve children of Indian heritage. Sections 8 through 10, as well as sections 13 and 14, provide for record access to the Office of the Child Advocate or its employees. And sections 11 amends KSA 382270. That provides when a secretary shall consider foster parents as prospective adoptive parents for children who are in DCF custody. And section 12 also amends the sync code and permits appeal of any order of placement of a child, including after termination of parental rights.
Thank you. Any questions for the revisers? Not seeing any. Could you remind those following along regarding Senate sub for House Bill 2070, Section 12 talks about permits appeal of any order of placement of a child. Does it expand who can appeal those orders, or what does Section 12 specifically do? I don't have the whole bill in front of me, but I can pull that up too.
In House Bill 2070, in Section 12, it amends KSA 382273. And so that current law allows that a person may appeal either a party or an interested party that they've gotten status through the sync code. They are allowed to appeal orders of temporary custody, adjudication, disposition, finding of unfitness, or termination of parental rights. And so those are all have been determined by a court to be before a termination of parental rights. And so what this section does is it amends that statute to include the placement of a child, so the order for a placement of a child to be appealable, and that shall include but not be limited to an order entered after the termination of parental rights, to clarify that that order, whether before or after the termination of parental rights, shall be appealable.
By any interested party or appealable by?
Yeah, Section 8
It's just
A says
okay.
party or interested party.
Okay, so 12 says what can be appealed. Okay, thank you. Any questions for the revisers? Not seeing any, so we can stand by for a few minutes for Senator Corson to join us.
WebEx
And then
Assistant is
currently
enabled to
receiving
save
services
audio
and training from
highlights.
the Department of Corrections. The Office of the Child Advocate in the House version is going to be an independent state agency, and it reports directly to the Child Advocate Advisory Board. And so that is something I will go over later. The Child Advocate appointment. So the Child Advocate in the House version shall be appointed by the Child Advocate Advisory Board, and it is subject to confirmation by the Senate. Requirements for the child advocate appointment is that the person holds a current relevant license that would authorize the individual to work as a licensed professional, as either a case manager, a behavioral health professional, or an attorney for a child, or has 7 years of experience in the field. The one prohibition the House bill does is that no current employee within the past 12 months, no current or someone who has been employed within the past 12 months as an executive or a manager is subject to oversight by the office can be appointed. The term of the person shall be 4 years. The salary is not addressed. Funding for the office, the Child Advocate Advisory Board would approve a budget submission by the Child Advocate and then go through the normal budget process as a state agency. There are some reporting requirements. So the office would annually report to the governor, the Child Welfare and Foster Care Committee on the House side, the Senate Standing Committee on Public Health and Welfare, the Joint Committee on Child Welfare System Oversight, and then as well as the Office of Judicial Administration. And then it also goes into what is to be included in that report, such as the number of complaints, the disposition of those complaints, number of children involved, the state entities named in those complaints, data on whether those complaints were found to be substantiated, and also recommendations for improving the delivery of child welfare services. And that includes recommendations to state law or DCF policy. The purpose of the office is to ensure that children and families receive adequate coordination of those child welfare services provided by state agencies. It allows for interaction with the court and the judicial branch. So the office is allowed in the House version to file findings or reports regarding a parent or child with the appropriate court with jurisdiction. They may issue recommendations regarding the disposition of an investigation to the court. But they are prohibited in intervening in divorce, protection from abuse, juvenile offender, child in need of care cases, administrative hearings, or civil or criminal proceedings. They are also allowed to file amicus curiae briefs on some of their findings. And then they may recommend recommendation of the Office in Appeals from a child in need of care matter in there as well. So they may use the AG's office resources for any of those needs. Record confidentiality related to records of children in need of care. All the records are going to be subject to federal and state disclosure restrictions applicable to the state agency or the entity that is providing those records. Any confidentiality requirement in the Child in Need of Care Code, which includes KSA 38, 22, 10, 11, 12, which are also amended in this bill to include that the child advocate has access. So the child advocate is also subject to the confidentiality restrictions on those who have access currently under statute. And then the additional items for the House bill, what the House bill does in Section 3 is it creates a Child Advocate Advisory Board. So those members are jointed or appointed by a grouping of the governor, the chief justice, the leaders of both the majority and the minority parties in both of the chambers. And the main duty is the board is to oversee the Office of the Child Advocate and to appoint the child advocate. And then lastly, it prohibits retaliation and any action taken against the office for their duties. So lastly, the one states all the statutes that are amended. So this 2211, 2212, 2213, 2309, and 2310 are all statutes that relate to access of child in need of care records previously mentioned. So those are all just amended to include the Office of the Child Advocate as a person who may access those records.
Thank you. And for those following along online, I think we can see that the legislature is interested in getting something codified. Right now, the child advocate is created through executive order. I'm not sure which executive order number it is, but something that the legislature is interested in looking at. So appreciate the comparison. Are there any questions for the revisor about the comparison between the House and the Senate bills? Not seeing any. I have just a question also. The Child Advocate Advisory Board, I see a couple places the duties of the board in House Bill 2043 would be to, well, the members would be appointed by the governor, chief justice, leader of the both majority and minority parties of the legislature, and the board shall appoint the child advocate, and the Senate version is the governor would appoint subject to Senate confirmation. And the other duties in the House bill would be for the Child Advocate Advisory Board to oversee the child advocate. Do I have that right? That's correct? Yes. Okay. Those weren't really questions, just making sure that I had clarification on what the Child Advocate Advisory Board would do in the House bill. So any other questions? Not seeing any. Committee, if there aren't questions for the revisor at this point, I would suggest that we stand at recess for just a few moments. I'd like to take a few minutes to take a look at the chart and kind of sit with that for a minute, if we may. So if we can stand in recess for 5 or 10 minutes, Madam Chair.
Sounds good. I need to talk to my team as well.
Okay, great. Thank you. And we don't really have an offer or anything. It's just kind of discussing what's been presented so far. So,
Okay.
thank you. I guess not recess, stand at ease, or that'd be great. Thank you. Okay, well, we will come back to order then. And it's my suggestion that since we're talking primarily about Senate Sub for House Bill 2070, the bill that's in conference committee, if you wanted to start with some amendment or some proposal that we could take a look at based on House Bill 2443, maybe that's a good place for us to start. If you're ready for that. If not, we can adjourn and come back later.
You know, I think I could be ready for like an offer. If I can find the right piece of paper. Okay. So if we would go with, were you talking about if we would go with our base bill or?
Well, I'm suggesting go with the base bill of Senate Sub for House Bill 2070, since that's the bill that's in conference committee. And if you have an offer ready to make or a part.
I don't
Okay.
on that one. There are a lot of more technical differences that I've not been able to. I mean, I know where I stand on our position,
Is
but
that something you maybe need to get with the reviser to draft up something? Or, and if you're not ready, we can come back after.
I'm not ready on if we're going to go with 2070.
Okay. Any discussion? Let's put that aside for a minute. Any discussion on Senate Bill 115, or we just want to wait on that? So
I'm good with
okay.
115.
Okay. Well, let's do this. Is it easier if we recess and then come back later, or is it easier to adjourn? Easier to adjourn rather than, right. Well, we all have to be back on the floor at 2:00. You know what? Let's stand at ease for a few more moments and let the chairs talk and stand at ease for a few moments, please. Thank you, committee, and those following along. There are clearly some differences between Senate sub for House Bill 2070 and House Bill 2443. So we need to take a look at that. And so we are going to be coming back at 3:30 today, 3:30 in 281 North. And that is hopeful that each chamber gets their work done and is off the floor in time. We do have a different committee meeting upon adjournment of the second chamber this afternoon, and then we will be meeting with you all at 3:30. So with that, then, appreciate everyone's attention, both in the committee meeting room and online, and we are adjourned.